Okay, let's get started. First, I'd like to ask everyone to mute themselves and switch your view to speaker view. Hello, everyone, and welcome to Human Resource Council meeting Marijuana and its Effect on the Workplace, brought to you by Connell Foley, NJM, Prime Point, Investors Bank, Association Member Trust, and the NJBIA HR Support Center. My name is Keith McDonald. I'm the Regional Sales Manager of Prime Point, HRMS and Payroll. And with us today is Lauren Iannacone of Connell Foley. Today's presentation is being recorded and will be emailed to you tomorrow along with the PowerPoint, so please be on the lookout for those. I'd like to draw your attention to the chat feature. Lauren is happy to take your questions, so get them in as they come to you via the chat section. This presentation is qualified for 1 CLE credit. If you would like to receive credits for today's presentation, please reach out to Jasmine Garrett by email. And Jasmine will enter her information in the chat now. After today's presentation, we will have 20 minutes to network. As I mentioned before, my name is Keith McDonald. I'm the Regional Sales Manager for Prime Point. Prime Point is a payroll and processing and human resource management company offering a fully integrated suite of technology tools. The company addresses the needs of small, mid-sized, and large business and is capable of serving companies with 1 employee to 10,000 or more employees. One of our major differentiators is the company's willingness and capability to customize the software configuration, which creates unique solutions to meet the needs of individual businesses. Prime Point also takes a different approach to customer service that starts during the sales process and continues through to everyday ongoing operations. We call this the Prime Point experience. To learn more, please go to our website at www.primepoint.com. As an affinity partner of the NJBIA, we're offering member discounts on our services. To learn more, please go to www.njbia.org/primepoint. If you would like more information or a quote, please enter your information at the bottom of that page and I'll reach out to you. So now, without further ado, Lauren, please take it away.
Thank you so much, and thank you for the introduction, and thank all of you for being here today with us this morning. Give me a moment to share my screen, and we will get this PowerPoint up and running for the presentation. There we go. Okay, so again, everybody, I'm Lauren Iannacone. I am a commercial litigator at Connell Foley. A large part of my practice revolves around helping employers with employee disputes. So one topic that has been very hot in 2020 and also 2021 has been marijuana. And what is it going to do to the workplace? In February, as many of you know, Governor Murphy entered into law recreational marijuana statute. So now, in addition to medicinal marijuana, which really took the floor in 2019, we also have recreational marijuana, which is now taking the floor in 2021. So without further ado, I'm going to go and get into the presentation this morning. Just so you know, I am going to cover medicinal marijuana, and I will also be covering recreational marijuana. As far as medicinal marijuana goes, there's really not too much new in this arena since 2019 and the case law that you folks are, very well familiar with. But I am going to do just a little refresher on that so that you have both components of marijuana and how it's going to affect the workplace. Briefly, I know that this is NJBIA, and I thank them for having me today, but I do want to make sure that you know that this presentation is New Jersey specific. So if you have offices outside of New Jersey, such as in New York, these laws certainly do not apply necessarily there. But to the extent you have employees traveling between states or any type of issue like that, please be sure to reach out for some specific advice so that we can better tailor any information to your specific industry and your specific question. Nothing in this presentation should be construed as legal advice. We are just giving a 9,000 square foot view of a very complicated area. And if you have specific questions, again, I urge you to please reach out. So let's get started. So first, we're going to start up with our medicinal marijuana program. So please note, marijuana is still illegal under federal law. Nothing has changed that. However, in 2019, Governor Murphy entered into law a medicinal marijuana program. which is the JCONIG Act. So the New Jersey Medicinal Marijuana Program presently serves over 80,000 patients in New Jersey. That's over 126% increase from last year. So you are likely to see this issue in your workplace. So here's the million-dollar question. Do I, an employer, need to tolerate medical marijuana in my workplace? Well, I'm a lawyer. So the answer to that question is obviously a little bit yes and a little bit no. So let's talk about some of the no's on this. Employers do not need to tolerate medical marijuana use and possession on the job or in the workplace. That means that you can have a zero tolerance drug policy for your workplace to make sure that there is no use or possession while at the workplace or on the job. That's the no part of the answer. As for the yes, it is unlawful to take any adverse employment action against an employee who is a registered qualifying patient based solely on the employee's status as a registrant with the commission. So what does this mean? It means if an individual or one of your employees is legally taking medicinal marijuana, has a registration card, and is taking the marijuana using this registration card, then you can't take any adverse employment action against that employee simply for using marijuana outside of work. That doesn't mean that they are allowed to possess it at the workplace, and it doesn't mean that the individual is allowed to use it at the workplace. This law wants to make sure that you're not discriminating against anybody for their use of medicinal marijuana outside of the workplace, and I think it's important to bear that distinction. So the definition of an adverse employment action includes employees and applicants when it comes to medicinal marijuana. So you can't discriminate against employees or applicants. This includes refusing to hire or employ an individual. It also includes barring or discharging an individual from employment. Requiring an individual to retire from employment, that would be adverse action as well. Discriminating against an individual in terms of compensation, terms, conditions, privileges of employment, that would be an adverse action. So let's get to drug testing in the workplace. So as an employer, what do I do if we have a drug testing policy and an employee or applicant tests positive for cannabis? Now, I'm going to limit this question strictly to medicinal marijuana for now, okay?
Here we go.
So that's just to make sure everyone's paying attention. It's the song that we know regarding 2 steps, but in this case, we have a 3-step. This is the drug testing in the workplace medicinal marijuana 3-step program, okay? So after the drug test is positive for cannabis, there's 3 steps that you as an employer need to make sure that you're doing, okay? Step 1, you need to offer the employee or applicant an opportunity to present a legitimate medical explanation for the positive test result. Okay, so let's say that there's a test, the employee or applicant comes back positive for that test. Now you have to have a conversation with the employee to give that employee the opportunity to present medical information, whether it be a registration card or some other type of legitimate medical explanation for this positive test result. That's step 1. Step 2, then the employer needs to provide written notice of the right to explain to the employee or job applicant and state the 3-day requirement that's noted in step 3. So not only do you need to have that conversation with the employer applicant, but you also need to put it in writing. So this is part of good documentation practices. To the extent that anybody needs help drafting any type of a notice regarding the right to explain to the employer applicant, please give us a call. This is really important because not only is the law making sure that you had that conversation, but they want to make sure that the employee had it in writing and has some time to respond. Step 3, within 3 working days after receiving the notice, okay? So you could receive that positive test result on day 1 and then wait a couple of days to figure out what you're doing. But within 3 working days after receiving notice, okay, so when you notified the applicant or employee of the positive test result, the employer applicant has the opportunity to submit information to explain the positive test result. That's option A. Okay, the employer applicant also has the right under this law to request a retest of the original sample at his or her own expense. Typically, this is a split type of a sample, and it would just be a retest of the original sample. Sometimes we get that question. The employer applicant may provide an authorization for medical cannabis issued by a healthcare practitioner or proof of registration as a legitimate explanation for the positive test result. Is that all of the legitimate medical explanations for the positive test result? No, I really can't imagine what they'd be outside of those categories, but to the extent you encounter anything that you have questions on, again, please be sure to give us a call if you have any questions on that. That's the 3-step under the medicinal marijuana program. Okay, let's see here. But an employee or applicant who does not provide a legitimate medical explanation may still be protected under the recreational marijuana law. And I raise that because prior to February 2021, it was cut and dry. Either an individual was taking medical marijuana and therefore was allowed to use marijuana, and that would be the only explanation for the positive marijuana test result, or the individual would be taking marijuana illegally. But now, due to the recreational marijuana law, there's a whole nother category that we need to take into consideration. So I urge you to make sure you follow the 3-step process, but also make sure that there's now an additional component if there is no legitimate medical explanation, because the conduct can still be protected by the recreational marijuana law. And you're going to need to conduct a separate analysis under that law that we'll get to on the second part of the presentation. So here are some caveats for you regarding this law. And I raise these because they don't apply to everyone, but for those industries that they do impact, they are quite important. So the medicinal marijuana law in New Jersey does not require employers to commit any act that would cause the employer to be in violation of federal law. It also does not require employees to commit any acts that would result in a loss of a licensing benefit pursuant to federal law, or that would result in the loss of federal contract or federal funding. So if you're a school, if you help out with homeless shelters, or you receive any type of federal funding for a public service, you may want to take this into consideration to see whether or not you would lose any benefits by adhering to the New Jersey provisions, because under federal law, marijuana is still illegal. So, second caveat, no employer shall be penalized or denied any benefit under state law solely on the basis of employing a person who's registered with the commission. Okay, so New Jersey wants to make sure that you know that if somebody does provide a legitimate medical explanation for using marijuana, medicinal marijuana, that that company will not be penalized or denied any benefit under New Jersey state law. Those are the 2 caveats for you under this particular provision. So let's have a hypothetical for you. Our company extended a conditional offer of employment premised on passing a drug test. After a conditional offer of employment was made, and before the drug test was administered, the employee told the HR representative that she uses medical marijuana. Now, this could be a little moment, right? The employee comes up to you and you say, oh my gosh, what do I do? And now the HR representative has some options. Option A, thank the employee and tell her that she does not need to take the test. She was so honest with me. She told me that she uses medical marijuana, so I don't need to test her, right? She was honest. She came forward. She told me. That's option A. Option B, tell the employee that she can go home because she's not eligible for the position based on her marijuana usage. We don't want marijuana here, no medical marijuana whatsoever. We have a 0 tolerance policy that includes medicinal, recreational, no marijuana, just no marijuana. So she can go home. The job offer is now rescinded. That's option B. Or C, ask the employee to still take the drug test. Under this circumstance, the HR representative still isn't sure, what to do, but they remembered that Lauren Iannacone from this presentation said I need to follow my 3-step process. So what's the HR representative going to do? What are you going to do? So for those of you who selected option A, and I'm going to go back to this slide, what if the drug test would show other substances in the person's system other than marijuana? What if there was something else? And that puts you in a whole different analysis. So make sure that even if an employee tells you that he or she is taking medical marijuana, that you thank that person for their candor, and that you let the person know that you still need to follow this process, because this process is something that all of your employees or job applicants are required to pass, and not necessarily to pass, but to take. So that correct answer here would be C. Ask the employee to still take the drug test. You want to make sure that you yourselves are covered. Okay, so disability discrimination, and I raise this because this is medical marijuana that we're talking about. Medical marijuana is medical treatment for those with qualifying underlying conditions. It is. It's been a legislative directive now. There was a recent case that came out in April regarding workers' compensation and about how medical marijuana can be a necessary part of legitimate medical treatment in a workers' compensation claim. I'm not going to touch on that here because it's not necessarily relevant, but medical marijuana is absolutely considered medical treatment as of this moment. So in Wild against Carriage Funeral Holdings Incorporated, a case that I'm sure many of you are familiar with, the court found that an employee's disability discrimination claim brought under the New Jersey Law Against Discrimination, the LAD, was sufficient to survive a motion to dismiss. The court wrote that plaintiff was not seeking an accommodation for the right to use medical marijuana at the workplace, but instead, he only sought an accommodation to allow for his continued use of medical marijuana while off-site and not during working hours. So a New Jersey LAD claim survived a motion to dismiss based on the facts that were in that case. A couple things to point out. New Jersey Law Against Discrimination has a 2-year statute of limitations. So it's a hefty law. Attorneys' fees are provided under the law if certain requirements are met. So, you know, the New Jersey Law Against Discrimination is a serious law. It does have some teeth. And, you know, you always want to keep it in the back of your mind as an employer so that, you know, you can avoid, you know, any type of discrimination in your workplace. I also want to point out something that not many people really talk about here. The Wild Against Carriage Funeral Holdings Incorporated. This particular law was not the J-Conic statute. It was really the precursor to that law, but I'm sure that, you know, the Supreme Court is kind of foreshadowing what would happen under the J-Conic medicinal marijuana law. So I just wanted to highlight that for you folks. Okay, so now we're going to jump right into the recreational marijuana part of the program, which is going to be the lion's share, I'm sure, of what everyone has questions about and wants to hear about, because it's really the new substantive bit of the marijuana legislation that came into effect this past year. So recreational marijuana is still legal under federal law. So let's talk about some statistics. 12% of Americans are identified as active marijuana users. 22% of Americans aged 18 to 25 used marijuana in the past month. The divide in gender usage is disappearing, with 48% of users as women and 52% of users as men. Now, I also want to talk to you about sales by generation. And just going back to my prior slide for a second, one of the reasons I mentioned the divide in gender here, and also the ages of individuals using marijuana, and in a minute I'm going to get to the different generations of individuals using marijuana, is because I think it's important when we're talking about marijuana that we need to be cognizant of any inherent biases that anyone may have. And that means managers, employers, supervisors. Anyone can be using marijuana at the end of the day. It doesn't necessarily need to be a teenage or a person in college. You know, teenagers, I hope not, because it would still be illegal since this is an adult provision. But the important thing is that it's important to remind your supervisors and managers that anyone can be under the influence of marijuana. And we shouldn't just be stereotyping individuals that we may think would be more prone to using marijuana. So let's talk about the 2020 cannabis sales by generational. So medical marijuana, let's start. If you were born from 1928 to 1945, They are 1% of medicinal and recreational marijuana users. If you were born from 1946 to 1964, this is the boomer generation. They are 17% medicinal marijuana and 13% recreational marijuana sales. 1965 to 1980 is Gen X. That's 23% of medicinal marijuana and 21% of recreational marijuana sales. 1981 to 1996, these are millennials. So this is 42% medical marijuana and 48% recreational marijuana. So when you're in your workplace, your managers and supervisors may be thinking of millennials as those individuals who are primarily using marijuana. I mean, the statistic supports that. But again, we want to make sure that we're not just singling out millennials, because Gen X, boomers, and Gen Z also have a high representation in the 2020 sales category. So Gen Z, 1997 to 2010, if you were born in this time frame, these individuals consist of 17% of sales of medicinal marijuana and 17% of sales of recreational marijuana. So again, I just bring this up so that you can have candid conversations with your managers and supervisors about stereotyping and making sure that everyone's cognizant that any individual could be susceptible to marijuana usage. So employees who tested positive for marijuana had 55% more industrial accidents, 85% more injuries, and 75% greater absenteeism compared to those who tested negative. It's important to make sure that we have a policy in place regarding recreational marijuana and what to do about it, because here it poses a serious hazard in the workplace, according to the National Institute on Drug Abuse. So as you know, on February 22nd, 2021, Governor Murphy signed the New Jersey Cannabis Regulatory Enforcement Assistant and Marketplace Modernization Act. I think that's why most of you are here. So prohibitions. Under this law, no employer may refuse to hire, employ any person, discharge, take adverse action against any employee with respect to compensation, terms, conditions, or other privileges of employment, because that person does or does not smoke, vape, aerosolize, or otherwise use cannabis items. And the main thing here is that you can't take any type of discriminatory or adverse employment action based on a person using or not using cannabis items. An employee shall not be subject to any adverse action by an employer solely due to the presence of cannabinoid metabolites in the employee's bodily fluid from engaging in conduct permitted under this law. Now, this is going to get us back to the hot topic of drug testing, because what this is talking about is the presence of cannabinoid metabolites in the employee's bodily fluids. So if there is a presence of cannabis in a person's bodily fluids, and this person was engaging in recreational marijuana usage, which is now permitted under New Jersey law, then an employer can't take any adverse action against that person. However, it says solely due to the presence of the cannabis in a person's bodily fluid. So what the recreational law has done is completely changed the landscape in terms of drug testing, which we're going to get to in just a second. So can I drug test my employees? Yes. An employer may require an employee to undergo a drug test under the following scenarios. 1, upon reasonable suspicion of an employee's usage of a cannabis item while engaged in the performance of an employee's work responsibilities. 2, upon finding any observable signs of intoxication related to the usage of a cannabis item. We're going to get back to this in a minute, because observable signs of intoxication is an important term. 3, following a work-related accident subject to investigation by the employer. And 4, randomly by the employer as part of pre-employment screening or regular screening of current employees to determine use during an employee's prescribed work hours, and employees need to be aware of this policy. So how can I tell if an employee is under the influence of marijuana at work? What are observable signs of intoxication? I mean, the main thing that everyone's focused on, rightfully so, is I want to make sure that individuals are not using marijuana, whether it be recreational or medicinal, in the workplace. And in order to make sure that the person is not using marijuana at the workplace and not under the influence of marijuana under the workplace, these observable signs of intoxication are going to be important. Ultimately, the law provides for a whole new type of person that's going to be able to test and assess observable signs of intoxication. But per the American Addiction Center, the observable signs of marijuana intoxication include red eyes, poor muscle coordination, increased appetite, delayed reaction time, anxiety, panic, delayed abilities, an initial liveliness, increased heart rate, distorted senses, and red eyes. So this new drug test, right? Because you can't only take an adverse action based on someone solely based on the presence of cannabis in a person's bodily fluid, right? So how do you take an adverse action? What do you do here? Under the law, the new drug test has two components to determine a state of impairment. First, you need scientifically reliable objective testing, and there's a new subjective component of physical evaluation. So if you want to test for recreational marijuana, you need to make sure you're not only using an objective, scientifically reliable form of test, but you also need to have a subjective physical component that's completed by a particular person, which I'll get to in just a second. So the objective component is your typical drug test. What do I mean by that? Urine, blood, hair sample, those are all objective, scientifically reliable drug tests. And I wanted to read this quote from the Drug and Alcohol Testing Industry Association on workplace drug testing. Aside from a breath alcohol test, drug testing does not determine impairment or current drug use. Rather, drug testing determines a specified amount or presence of a drug or its metabolite in urine, blood, or an alternative specimen. There is a minimum measurement applied to drug testing so that only traces of a drug or its metabolite above a specified level is reported as positive. This measure is known as a cutoff level, and it varies for each drug. So I raise this because it's important to remember that current impairment is not measured under drug tests for medical marijuana. What do I mean by that? Well, saliva. Usage of marijuana is shown up to 34 to 48 hours after the last use of marijuana. That's important because it's not showing a current impairment. Under the law, a person can use marijuana the night before, let's say right after work the day before, and then come into work the next day, not be impaired on marijuana, but it would still show up on that individual's saliva test 34 to 48 hours after that individual's last use. Does not show current impairment. Under a urine sample, urine samples can show marijuana 1 to 30 days after last use. Infrequent users who use marijuana less than 2 times a week can test positive for 1 to 3 days after using marijuana. A moderate user can test positive for 7 to 21 days after last use. A heavy user can test positive a month or longer after last use. So urine samples do not show current impairment of an individual who has taken marijuana. A hair test can show a positive result up to 90 days after a person uses marijuana. Studies argue it's not as likely to detect the presence of marijuana in light users, and a hair test can also detect secondhand exposure. So hair tests are not reliable to determine current impairment of marijuana. Blood tests. A positive test result can be shown up to 36 hours after an individual last uses marijuana. So after work on Friday, let's say Jimmy and Martha decide, they're both your employees, they decide that they want to use marijuana after work on Friday. They use marijuana after work on Friday. It's not on your premises. They're not consuming it on your premises. It's completely after hours, and they're allowed to do so under the recreational law. They show up to work on Monday. Well, you know, there's a possibility that the marijuana can still be in their system if you use a saliva test, if you use a urine test. It's unlikely it would show up in a hair test. Maybe it would show up in a blood test. But the reality is that's not showing a current impairment of your employee, because these individuals used marijuana Friday and now they're returning to work on Monday sober. So testing is not where it needs to be. It does not inform us of impairment. It does not inform us of a specific time of last use. These are the questions that you as an employer want to know. Is this person impaired? Can this person be here operating a piece of machinery or interacting with customers or interacting with students? And the testing, unfortunately, is not where it needs to be to give employers those answers. The testing for objective current impairment needs improvement. So if you decide to drug test, the physical component of the drug test must be performed as well. And that's likely in response to this ambiguity and this difficulty in determining whether or not a person is currently impaired under the scientifically reliable method. That's part 1 of the drug test. So part 2 of the drug test is this physical component, and that is to be conducted by a new position, brand new, that the law created, the workplace impairment recognition expert. The workplace impairment recognition expert is a brand new position, like I said. The commission is going to prescribe standards in a regulation that have not come out yet for workplace impairment recognition experts to receive a certification. This certification can be issued to any of your full-time employees, part-time employees, or others who are contracted to perform this particular service on behalf of an employer. The workplace impairment recognition expert certification will be granted to those individuals based on education and training in the detection and identification of an employee's usage of or impairment from a cannabis item or other intoxicating substance, and for assisting in the investigation of workplace accidents. So just to get back to the workplace impairment recognition expert certification, they're not offering the certification just yet. We're waiting for the regulations so that when they come out, the regulations are going to put together a program where individuals who are part-time employees, full-time employees, or an outside service company like we just talked about, they will be able to get the certification and then assist in determining whether or not a person is currently impaired from cannabis. So not only do you need to take that saliva test or that urine sample, but you also are going to need to now do this physical component, which needs to be conducted by the workplace impairment recognition expert. That individual will be able to detect, identify, and give some insight on whether or not that person is presently and currently under the use of an intoxicated substance. So an employer may use the result of drug tests when determining the appropriate employment action concerning the employee, including but not limited to dismissal, suspension, demotion, or other disciplinary actions. Now, many individuals and many companies are going to have a zero tolerance drug policy, meaning you can't use it here, you can't be impaired while you're here, you can't sell it while you're here. We don't want to see any marijuana whatsoever on our premises, regardless of the fact that it's legal now. But there are other companies that may take the position that, you know, we have a different type of a spirit and a theme for our company. We want to give individuals who tested positive for marijuana a last chance. Though that's a different type of a policy. But regardless, make sure that you do have a policy. And whatever policy it is, make sure that you are administering that policy equally to all of your employees, so that from today going forward, or from February going forward, when the law was enacted, that you have a consistent policy so that you're treating all of your employees equally under the conditions that are presented. And now would be a good time to remind you to document. It's not enough that you are focusing on a positive test result from a urine sample or a positive test result from a workplace impairment recognition expert. What you want to do is really focus on the conduct that led up to those positive test results. Why are you drug testing this individual to begin with? Was there an observable sign of intoxication? What was that observable sign of intoxication? Make sure that you get these items documented. If there's video footage of a particular sign of intoxication, make sure it's preserved, put it in the file. You want to make sure that you're documenting and preserving everything that you used in your analysis to determine that this individual was under the influence of marijuana. Okay, so I'm sure you have some questions. Nothing in the recreational marijuana law requires an employer to restrict its right to maintain a drug and alcohol-free workplace. So you can still say no drugs, no alcohol in my workplace whatsoever. That includes recreational marijuana. Nothing in this law requires employers to permit or accommodate the use, consumption, being under the influence, possession, transfer, display, transportation, sale, or growth of cannabis or cannabis items in the workplace. This is hugely important, and I can't urge you to really take each word and parse it out in terms of a drug policy, because you have to make sure that it's not just use that you're prohibiting if you decide to have a complete drug and alcohol-free workplace, but it's use, being under the influence, possession, sale, growth, transfer, display. All of these terms mean something different. And they want to make sure if you decide to have a zero tolerance drug and alcohol-free workplace, that you're incorporating all of these in your policy. Nothing in the law is also going to require employers to change or limit their ability to have policies prohibiting the use of cannabis items or intoxication by employees during work hours. You can say no. You can absolutely say no. So here are some carve-outs regarding some federal law and federal contracts. The law does not intend to amend or affect in any way any state or federal law pertaining to employment matters. The law does not intend to prohibit a recipient of a federal grant or an applicant for a federal grant from prohibiting the manufacture, transportation, delivery, possession, or use of cannabis items to the extent necessary to satisfy federal requirements for the grant. The law does not intend to prohibit a party to a federal contract or a person applying to be a party to a federal contract from prohibiting the manufacture, transportation, distribution, delivery, possession, or use of cannabis items to the extent necessary to comply with the terms and conditions of the contract or to satisfy federal requirements for the contract. So there's this federal component here that's New Jersey did take into consideration. So I'm going to give you a hypothetical. All of your employees are under 21. And one of them tested positive for marijuana following a urine test. Do you, A, terminate her employment because she tested positive? We have a zero tolerance drug policy in our workplace. This person tested positive. Well, I have to terminate it. Option B, I'm going to ignore the result of the drug test because recreational marijuana is illegal and people her age probably are using recreational marijuana. Well, I'm going to ignore it. Recreational marijuana is allowed. That's what everyone's been telling me. So I guess I have to just ignore this drug test. Or C, will you do something else? Now, I'm going to give you a second to think about this. And I urge you to go back to the hypothetical because there's a couple tricks in here. Trick number one, all of your employees are under 21. And we are talking here about marijuana. So are we talking about medicinal marijuana or are we talking about recreational marijuana? We're talking about recreational marijuana. If you're under 21, you still cannot use marijuana unless it is for medicinal purpose. That was trick number one in this question. Trick number two in this question is this individual tested positive for marijuana following a urine test. Well, before I had mentioned that there's two components to a drug test, an objective, scientifically reliable test, which is a urine test, for example, and also a physical component. That was the second trick. So Again, I urge you, was this an appropriate drug test? Did I need a second component here, the physical evaluation? So under recreational law, employees could not take an adverse action for positive urine results alone. This individual needed to have a physical evaluation. That would be completing that circle of analysis. However, she's 21. So make sure that under the medicinal marijuana program that you're doing the 3-step. If she's under 21, she can't legally use recreational marijuana, but she may have been legally prescribed medicinal marijuana by her primary care doctor or other physician for a medical reason. And you need to make sure that you take these things into account. Now, if the employee was over 21, what I urge you to do is follow the 3-step for the medicinal marijuana program. If the employee does not provide you with a legitimate reason for the positive result, then you can continue the analysis under the recreational law. Under the recreational law, was the employee impaired during work hours? You want to focus on the impairment, not the positive test result. Again, make sure that you remember that your testing needs to have both components. Scientifically objective test and also a physical examination. So the Regulatory Cannabis Commission is now charged with regulating medical and personal use cannabis industries. Department of Health is no longer controlling this area, and we are waiting for those regulations diligently to come from the Cannabis Regulatory Commission. So I'm sure that there are going to be a lot of questions, and I hope that a lot of the questions that you may have today will be answered by those regulations. So unfortunately, I may not be able to answer many of your questions. Those regulations are due this August 2021, but that may change. So again, we are waiting for regulations. One thing that colleagues in this area have been talking about is how recreational marijuana is technically not for sale yet. So no individual should be using recreational marijuana in New Jersey technically yet. That's just part of the conversation that a bunch of my colleagues have been having. But it still is a dicey territory for employers. So I want to make sure that we are talking about a Senate bill that was introduced by Senator Sarlo. And it's not something that has been enacted into law, but it's a cleanup bill. And it's important because, again, it's part of the conversation that many of my colleagues and I are having regarding expectations and what to do regarding some of these new implementations. So such as the workplace recognition expert. Under Senator Sarlo's new law, any employer may determine to employ or not to employ a workplace impairment recognition expert in the employer's discretion. So it gives you the option. Senator Sarlo also wrote, nothing in the subsection shall be interpreted to require that an employer use a workplace impairment recognition expert for either drug testing or determinations of suspicion of an employee's usage of a cannabis item while engaged in the performance of the employee's work responsibilities. Nor shall the use of the workplace impairment recognition expert be deemed the industry standard for testing or making such suspicion determinations. An employer shall be free to use scientifically reliable testing services and to exercise its own judgment in making good faith suspicion determinations. So under Senator Sarlo's bill, the workplace recognition expert can go by the wayside. It's possible. We don't know if there's going to be more modifications to this bill, but I just bring it up because I want you to be aware of what's on the horizon in terms of legislation. It may go nowhere. It may go into law. We just don't know yet. So safety-sensitive positions is also a very hot topic when we're talking about recreational marijuana, especially those in the heavy construction industry. Senator Sarlo has ties to the construction industry, and he made sure to address this in the bill. No employer shall take any action which has the effect of prohibiting an employee using cannabis items during non-work hours, except upon determination by an employer that the nature of the work of an employee at a critical infrastructure facility or a construction site has an exceptionally high risk of potential harm to other employees or to public safety if the employee were to be impaired through the use of cannabis. This is huge. I think all construction industries, when they heard this, said, you know, we need to do something about this. We absolutely need to take control of the situation. And I know that's something that a lot of individuals are pulling for. The approval to designate categories of such employees or a specific employee of an employer shall be made by the commission upon application of the employer. So this gives the commission control to say, yes, you fit within the safety sensitive type of position, posing an exceptionally high risk of potential harm to other employers or public safety. And it also gives employers the opportunity to make this application to get this exemption. So just something I want you folks to be aware of, because this is something that everyone's talking about. So some action items. Please make sure to update your drug and alcohol policy. Many drug and alcohol policies that I see contain the word illegal. They prohibit all illegal drugs. Well, marijuana is no longer an illegal drug. It is still an intoxicating and impairing drug. So make sure that when you're looking at your policy, you're looking for the word illegal to make sure that it also encompasses marijuana and alcohol for that matter. You want to ensure that managers and supervisors are trained on reasonable suspicion testing and observable signs of marijuana intoxication. This is something that I encourage you to do in the interim, because ultimately an individual that you designate should be a workplace impairment recognition expert certified individual. But in the meantime, you know, reasonable suspicion is important for your managers and supervisors to be aware of. You're going to want to designate an individual, or at least two, to obtain that workplace impairment recognition expert certification. And we're also going to keep an eye on Senator Sarlo's bill to see if this requirement goes away. One of the things that's important here is why we're recommending two. Well, what if one of your workplace recognition experts is on vacation? Well, hopefully the other one will be in the office. What if one of your workplace impairment recognition experts is the person that you're suspecting is under the influence? Well, now you have somebody else that can perform that second part of this drug test. So we are at the present recommending at least two individuals to obtain this certification. Give some thought as to you, an employer, how you're going to measure impairment, because those observable signs should be in some type of a policy so that you can point to them objectively in and when you are documenting how you went about evaluating impairment. Provable adverse impact is a very hot term if you're a federal contractor or you're involved in federal contracts. If you are and you have questions on that, that's something that, you know, we can certainly talk about at another time when we have a little bit more time. If discipline is warranted, focus on conduct rather than the positive test result. I encourage you that the positive test result is not the reason why a person should be disciplined, but rather it's the danger that this person poses to fellow employees, to the public safety of other individuals or passerbys, what this positive result means for your workplace. So if you are considering discipline, please focus on the conduct. And remember the age of your employees. Recreational marijuana use is permitted if the employee is 21 or over. Medicinal marijuana use is permitted with proof of eligibility. So if you own an ice cream shop down at the beach and your employees are generally, you know, 16 to 18 years old, you know, you want to make sure that recreational marijuana is not even something that you folks are talking about, because the individual will need to be 21 or over. So thank you very much. I'll now open up the floor if you have any questions.
Great. Thanks, Lauren.
Thank you.
Great presentation, very informative. We have one question here. When will the regulations for recreational marijuana come out?
We are anticipating them to come out in August of this year, so just a couple months away. The commission has met a couple of times. However, I haven't seen anything on the regulations even percolate just yet. So be patient. As soon as something comes out, we'll be sure to issue some type of a blast so that you can be made aware.
Okay, great. Doesn't look like there are any other questions. Doesn't look like there are any other questions. So well, thank you again.
Thank you.
Lauren, did you have any last words or thoughts?
I thank everyone so much for their time today. I know it's a lot to process. There's a lot of components with the workplace recognition expert and now the second part of a drug test coming into play. So if you have questions, please reach out. It's important to evaluate your drug policies to make sure they're as comprehensive and clear as possible, because we want to give notice to everybody about what the expectation is so that the employees can meet that expectation. So
And I'm sorry, Lauren, I didn't mean to cut you off. There are a few questions that are coming in.
okay.
So is there any indication of a test that will be able to test impairment?
We keep hoping. We've heard, talk down the pipeline that people working on breathalyzer testing and other types of testing to give a more adequate result similar to alcohol testing. But at this time, there's just no test that really fits that bill. But, it's something that we're certainly monitoring.
Okay, great. And where can we obtain a copy of the presentation?
And my understanding is it'll be emailed by Jasmine after this presentation. So you should be getting it within a couple of business days.
Great. Another question. Who will provide the training for the expert certification?
That's something that we are waiting to hear back on in the regulations for some more details on that. It's going to be similar to the drug impairment expert. It's provided by the police academy. So I know that may be a component of this that they're considering, but more information on the workplace impairment recognition expert should be coming down in those regulations. I know one thing that we're very anxious to do is get a copy of any materials that are provided in that program so that we can make sure to update drug and alcohol policies to include observable signs of intoxication straight from the workbooks that are provided to those individuals as part of the certification.
Okay, great. Can you speak to the issue where the drug testing industry will improve their product so as to possibly measure impairment in a meaningful way?
I really wish I could. It's such a hot topic because impairment is from the slide that I showed you folks about the hair test, the saliva sample, the urine test, it's just not there yet. And I wish that there was something that we could do to kind of urge this along. But at this point, it doesn't seem that there's a test that's, there just yet. So everyone's in the same boat. I think we all have the same concerns. And the drafters of this particular piece of legislation, I think that's really why they put together that two-piece component of the drug test. So on one hand, we have the observable signs of intoxication through scientifically reliable methods. So at least you know whether or not that employee did use marijuana, at least recently. It's something. It's certainly not dispositive. And then in terms of measuring current impairment, that's really where you're going to be relying on your workplace recognition expert.
Does it matter if the medical marijuana card is not from New Jersey and the employer is a safety company?
I think that would be relevant, but it's a good question to see whether or not there's going to be reciprocity on this issue. It's something I'm going to want to think about. So I will ask just if someone could just write down your contact information, and we'll be sure to get you an answer on that.
Okay, great. In regards to Danielle and Stephen Camino's law, how does this work with the legalizing of marijuana?
I'm sorry?
It said, in regards to Danielle and Stephen Camino's law, how does this work with the legalizing of marijuana?
I'm not sure I necessarily understand that question, but if you have something specific that you want to discuss in more detail, Nicole, please reach out to me and I'll be happy to have a conversation with you offline. Absolutely.
And what about the Hound marijuana breathalyzer that is available in California?
No, I'm unfamiliar with a Hound breathalyzer. I do know generally, just from engaging in conversations with my colleagues and some of the experts in this industry, that the breathalyzer isn't there yet. And I'm not sure if that's necessarily the Hound product that you're referring to that's available in California, but it's just my general understanding that the breathalyzer as a whole, as a product to measure current impairment of cannabis, is not necessarily there. I can take a look into that particular product though. I'd be interested to see what it's about.
Okay, great. That looks like that's all the questions. So thank you again, Lauren.
Thank you.
Don't
Thank
forget,
you.
all of you will be receiving a recording of today's presentation and the PowerPoint slides via email.
Thank you
So,
for having me.
great. Now we'll get started with the networking. Jasmine will place you in 2 rounds of breakout rooms, each for 10 minutes. Please take this time to network with the speaker and your peers. The countdown clock will appear when the first session is ending. All you need to do is say yes if and when a pop-up appears, letting you know you're being redirected into the next room.